Medical malpractice can be a confusing and often misunderstood area of law. Let me take just a moment to clarify what it really means and how it impacts those affected. Medical malpractice is not simply a bad outcome. Sadly, bad outcomes, even tragic outcomes, can occur every day, and sometimes even when a medical provider does everything right. It becomes malpractice only when a bad outcome can be traced back to medical negligence. The most common and disturbing type of malpractice, in my opinion, is the failure to communicate effectively between providers. For example, a suspicious test result might not reach the primary care physician, or a patient might not be informed about potential cancer, leading to a delayed diagnosis. Another example is when a provider fails to convey the urgency of a patient's condition to a specialist, resulting in delayed treatment and permanent injury. We also see cases where a provider jumps to the easiest diagnosis without first ruling out serious conditions. Medical principles generally require a thorough examination and testing before jumping to a diagnosis. If a provider fails to do so, that often will violate the standard of care. Medical malpractice cases need experts to prove the standard of care and that an avoidable injury occurred. Juries oftentimes will side with medical providers, and so many cases across the state end with no recovery whatsoever. These cases are very expensive to develop, and so an experienced medical malpractice attorney will only typically take on a case that has a very strong likelihood of success. If someone has been seriously injured due to medical negligence, they're going to need the assistance of a skilled lawyer with the resources to take on these types of cases. I'm happy to say that the Haynes firm is one of those firms.